Let me get a little bit of background before I introduce our esteemed expert on the FOI. A couple of months ago, he and I were having coffee, and if you're a regular reader of Professor Steinbuch's column, as I am, you know he and I don't agree on everything. We disagree on a lot of public policy things. We probably didn't vote the same way last fall. We disagree sometimes about the scope of the public library and what's mission creep and what's core, and sometimes whether the First Amendment applies or doesn't apply. But there is one thing that we really, more than one thing perhaps, two things I'll say. One thing we agree on is the centrality in a democracy of what you can call broadly open records and open meetings laws, otherwise known as the Freedom of Information Act. And as someone in a public job for the last 10 years, it has complicated my life. That didn't start when I became the director of the library. I remember trying a lawsuit down in Nevada County years ago, and I was representing the Prescott School District. They'd had a fire in their high school, and it burned to the ground. The argument was over whether the insurance paid for the full cost of building back the high school gym and everything, or whether it was what was the value of the gym in Prescott, Arkansas, circa 1995. But I realized at that time that what Professor Steinbuch could have taught me if I'd been one of his students is that the attorney-client privilege does not supersede the Freedom of Information Act. So all communications with your counsel are not privileged in a degree that keeps them from being subjected to FOI. So even before I became the library director, I knew that FOI is a complicating part of your life if you're dealing with any sort of entity that spends public money. But notwithstanding that, I will stand up alongside the professor and others and attest to its importance in accountability and transparency for public entities and for public employees, particularly in the way they spend money. And so last year, there was an effort, unsuccessful unfortunately, to strengthen the FOI law in Arkansas after the governor, you might remember this, the governor had called a special session and there was some effort to modify the Arkansas FOI law. They've been around since '66. He'll probably give us a little bit of the history. And then there was a group, a spontaneous effort in response to that from people led by Professor Steinbuch and a friend of mine, Nate Bell, and others. And Nate Bell solicited me for a contribution. I said, sure, I'll support that, even though I've been hoisted on the petard of FOI once or twice, sometimes at the occasion of my friend here. But I said, that's a valuable thing. We need to have an FOI that's strengthened. So they worked hard. It didn't get on the ballot, unfortunately. So that's one thing he and I significantly agree on. The other thing is, he might be too modest to say this out loud, but he is the unparalleled expert on this subject in Arkansas. And so I agree on that. So I asked him, we were having coffee a couple of months ago, why don't you come do a program at the library on the FOI? And he has graciously accepted. He had to ask for a little bit of grace until the semester was over, but now he's gotten all those papers graded that they pay him to grade, and so he's here. And he's going to talk to us a little bit about this. Maybe he'll talk a little bit about what happened in the last legislative session. When there's an effort to modify or tinker with the FOI, nobody goes to that without going to Rob Steinbuch to talk to him. And another occasion of maybe a strange bedfellows was I was trying to reach Clark Tucker one day about something. He said, well, I got to get off this call. Professor Steinbuch's calling me. We're working on a bill about the FOI. So you might not expect Clark Tucker to be voting with Professor Steinbuch in lots of ways or agreeing on public policy, but they agreed on this central importance of the FOI. So that's why he's here. And so people, even those of you who don't work in public sector or not journalists or not interested in it, can have some appreciation for it. He's a native of New York, I think. He went to the law school in Philly, went to college in Philly and law school in New York. Before he came to Arkansas, he had a stint as a clerk for a U.S. Court of Appeals judge, Judge Evans. He worked for the Justice Department, and he also had a stint on the Senate Judiciary Committee, the U.S. Senate Judiciary Committee staff. And I think most immediately before you came here, you were at the University of Georgia, maybe, is that right?
No, I visited, while I was teaching here, I visited.
Okay, all right. We're lucky to have him in Arkansas. He is a unique scholar on this subject, and we're lucky to have him here at the library tonight. I appreciate you coming.
Thank you, appreciate it.
Thank you. Give him a big hand.
Well, Nate said I may be too modest. That's an accusation rarely thrown at me. But I will add to that that I agree, oddly enough, that I am the state's expert on the Freedom of Information Act only because I was the co-author on this book. Now I'm the sole author, because the book series was started by a fellow out of University of Arkansas at Fayetteville, John Watkins, and then a colleague of mine who has since left and gone to another law school, Rick Peltz, now Rick Peltz Steele, joined that, I think in the 4th edition, let's say, and then I joined the book in the 6th edition. Well, both of them have moved out of the state, so I am the state's foremost expert because I'm the only one who does it. So it doesn't take much to be the expert anymore.
It's the 7th edition now, or 6th edition?
Well, this is the 9th,
Okay.
and I'm working on the 10th. When I took over the book entirely, I brought it to a national press, LexisNexis. It was being published out of Fayetteville, and I brought it to a national press, and they like to keep it updated every 2 years or so. They also hiked up the price quite a bit too, so it's not an inexpensive book. But I'm sure that Cal's has bought several copies of it for all readers to have. So let's talk about what the FOIA does. We'll also talk about some of the bills that were enacted, and then of course take any questions. If you have a specific question as to something I'm saying at the time, feel free to interrupt. That's fine. But if you have a more general question, then we'll save those till the end. So the Freedom of Information Act was enacted by a Republican governor and a Democratic legislature. Of course, sort of blue dog Democrats in the South, right? And in 1967, and it's been modified many times since. There are two components to the law. One is your ability to get records from government entities. The other one is what we generally call the Open Meetings Act, but it's really just a portion of the Freedom of Information Act. And that allows the public to observe the workings of governing bodies. And I'll talk a little about that in a few moments, but I will tell you now that my emphasis, my work, both in scholarly work as well as in litigation and even in advising folks, tends to focus on the first part, getting records. And I generally think of the two parts, it's the more important part. And as Nate aptly pointed out, one of the key provisions, one of the key purposes of getting those records is to see how your money is spent. So you can make a request of any entity and ask how it's spending certain monies. You can do a lot more. You can ask for any record. But perhaps it's a good time to start out with a basic understanding of what you can ask for and what you can't. Not in terms of exemptions, and I'll talk about those as well, but what it means to make a FOIA request. Because a lot of people don't understand that, and that's okay. It's a complicated law. A FOIA request is a request for government records. It's not what we call in the law an interrogatory. So you can't say, tell me all the times the governor went to Spain, right? That's a question. But you can say, send me all records that show the number of times the governor went to Spain. And there may be no records. Of course, if that really was your inquiry, you would hone that request by saying, send me the records that show where the governor has traveled over the last year, say. So being clever in how you ask the question is very important. Now, it's true that sometimes people abuse the FOIA. And this is what you hear from those who tried to narrow the FOIA. As Nate pointed out, the governor called a special session, and David Ray, who's a state rep from North Little Rock, was the lead sponsor of a bill to narrow the Freedom of Information Act. And as Nate again pointed out, I helped lead, I didn't only lead, but I helped lead the efforts to fight that, and we were successful. We stopped the attempts to significantly limit the Freedom of Information Act. And I like to say, much like my relationship with Nate itself, is it was an alliance of blue hair and purple hair. Right? So the blue hair are the old lady conservatives, right? And the purple hair are the lefties. So you put them together, and that's a good alliance.
Some of us are the no hair.
Right, exactly. And mine's just the white hair. It doesn't fit either category, does it? But it was really interesting to see the people really of completely different perspectives. The Tea Party types on the right, they came out in force. Folks on the left, and even the sort of far left, the progressive types, they came out. Where you find attempts to restrict the Freedom of Information Act generally is by entrenched power. So it doesn't matter if it's left or right. It's who's ever in power. And I just published an article, I don't remember where I published it, maybe in a journal, a secondary journal in University of North Carolina, I think, that uses two examples. Uses Arkansas and New Jersey. Arkansas, of course, significantly Republican. Republican legislature, 85%. All the, what we call constitutional offices are Republican, meaning governor, what's the vice governor, what do you call that?
Land commissioner.
No, but the position you ran for, lieutenant governor, right. Yeah, right, all those positions now, yeah, every one of them in Arkansas, Republican. New Jersey is the opposite, all Democratic, and generally the case, of course, famously, what was his name, the big guy who was from the governor? Christie, right, Chris Christie was a Republican, but generally, and then Tom Keene also back in the 80s or 90s, but generally a very Democratic state. They made essentially the same effort that we made here, or that was made here. We didn't make it, right? But that was made here to restrict the FOIA, and they succeeded. So we beat New Jersey. We did better than New Jersey. We stopped that effort. And I won't go through all of the elements of that law, of that bill that attempted to change the FOIA, but it was significant. Perhaps chief among them is in the federal FOIA, there's an exemption, I think it's deliberative process privilege exemption, which swallows the federal FOIA. That's the problem. The federal FOIA is a toothless tiger, and it's not particularly well enforced. There's a time limit in it, but unless you sue, you won't get your records within that time limit. If you sue, then they speed up providing you the records, and you probably get some attorney's fees to boot. That exemption doesn't exist in the Arkansas FOIA, and there was an attempt to bring in that exemption. And it's just this wide exemption. Think of it, deliberative process. Whenever the government's thinking about something, we don't want to interfere with that, and so that's exempt from the FOIA. Well, that's all government does, right? Is think about something and then execute it. So we should get the records only after execution? That seems like a problem. And that was one of the, they tried to cut the attorney's fees provision. There's a provision that says if you win a case, you get reasonable attorney's fees. Not any attorney's fees, just reasonable attorney's fees. I had litigated a case, co-litigated, there's some better word for that, a case up in Fayetteville, and we won that case. And so we put in for attorney's fees. And the attorney has to write an affidavit, a statement, saying this is what I charge, and this is the number of hours I worked. So I wrote mine. Now my colleagues had put in for, I can't remember if it was $250 or $350 an hour. In my affidavit, I wrote, I charge $1,000 an hour, and I'm worth every damn penny of it. I said, however, I'll accept what my colleagues are asking for. So I didn't actually seek the $1,000. But rest assured, by the way, $1,000 an hour is high for Arkansas. It's not high for the country. I think in New York, maybe $4,000 an hour. I mean, it's multi-thousands of dollars an hour that the attorneys make. Then when the bill was being argued, someone said, Well, and there was one attorney who sought $1,000 an hour. Well, it could only be me. Who else would have the nerve to even put that into an affidavit, no less file it in a court? So when I testified, I said, I know who she's talking about, and it's me, and I didn't ask for it, but as I mentioned to you a moment ago, I'm worth every damn penny of it. And that's what people are often afraid to say, which is, well, I'm not asking for a lot. Oh, I'm asking for a lot, because I do a lot. It's rare that you get, the judges don't give high attorney's fee awards. They give appropriate ones, but not high ones. I had another case that I litigated myself. I didn't ask for $1,000. I think I put in the affidavit that I'm worth it. And again, I can't remember if it's $250 or $350, because frankly, folks, I don't do it for the money, but I ask for the money because these entities need to understand that there's a price to be paid. And so I asked for whatever that normal amount was, and I provided all the hours, and I spent a lot of time on it. And the judge said, okay, I think that's more time than you needed to spend, and he's perfectly entitled to say that, right? Because the law says a reasonable time period, and the judge has the discretion to determine what's reasonable. And he cut it down, and I got a check, and that was fine. Doesn't matter. Anyway, yes, sir. And then we'll.
You said that the exemption is small as in kind of federal request.
That's right.
Doesn't have there's something that doesn't have its own counterpart in Arkansas.
That's right.
It sounds similar though to something called the working papers exemption. Is that?
So let's talk now about the working papers exemption. It's interesting. Part of the question is, what does the working papers exemption mean? Let me see if I can find it quickly here. I might not be able to, because I'd love to read it to you. Let's see here. Maybe 305. One of the things the book needs is a better index, frankly. No, that's not it. So then it would be in probably 501. Let's see. And if I can't find it quickly, then I'll do it off the top of my head. Let's see. Here it is. So 501 Part 9 in my book, for all of those who are following along, which I know is one person. The section exempts from disclosure unpublished memoranda, working papers, and correspondence of the governor, members of the General Assembly, Supreme Court justices, Court of Appeal judges, and the Attorney General. So, first thing we notice about that exemption, it's limited to a rather small group of people. That's the governor, the legislature, the Supreme Court, the Court of Appeals, not the other judges, by the way, and the AG, not the other constitutional offices, no other state offices, no county offices, no city entities. None of them can enjoy that exemption. So it's limited in that way. And then one might say, well, the governor oversees all the executive agencies in the state, after all, right? So doesn't that cover all of those agencies? And the courts, and indeed the governors generally have not interpreted it that way. So it only covers the actual operations of the governor. There's some dispute, by some dispute meaning I disagree with somebody who said the contrary, as to whether if the governor writes a letter to somebody, you can get that letter. Yeah, the governor, the governor and the AG currently take an odd position, and that position, and I don't know if it was previous governors and AGs took this position, but I only saw it recently, where they said, oh, well, you can't get any of our correspondence from us. And of course, it says unpublished memoranda, working papers, and correspondence of the governor. I posit that unpublished applies to all of those. They say it doesn't apply to all of those. The Supreme Court has implied that it doesn't apply to all of those because the Supreme Court had a FOIA request when there was this controversy with, was it with Hudson or Baker? I can't remember now, but, oh no, it was with the Hudson. So Hudson got in a fight, Justice Hudson got in a fight with the office that disciplines attorneys about releasing some of her correspondence, and the whole court wrote an opinion without a lawsuit, sort of an administrative order saying that you can't get the records from the Supreme Court, but you could get it from the recipient. That's just a lousy interpretation of what that sentence says. So in short, if it's possible at this juncture, that exemption has its limitations on what we can get, but it's far less significant than what is the federal version. So let's step back for a moment, right? Let's talk about who are we making FOIA requests of? And we're making FOIA requests of any government entity. It applies to the state, applies to county and to city governments. And you can make a request of any of those. There's no format in which a FOIA request has to be made. Sometimes you'll hear agencies say, oh, well, you have to go on our website. No, you don't. Oh, you need to put in, no, you don't. Like, you don't need to finish that sentence. Now, with that said, there's a smart way to make a FOIA request and a foolish way to make a FOIA request. And the smart way to make a FOIA request is in writing. And the easy way to make that FOIA request is to do it via email. Many entities have FOIA point persons, and they'll say so right on their website. So if that's the case, send it directly to that person. If they don't indicate that, then you send it to the top dog, the head of the agency. There's a new law, I think Alan Clark passed it, I worked on that law, that says if you send it to the wrong person and the person knows the right person, they're obligated to tell you who that is. And so I always recommend that you put that in your letter. You say, hey, if you're not the right person, please let me know, pursuant to the law, no less. I always recommend, unlike my columns, to write a polite FOIA request and to write a limited FOIA request, because you can always ask for more. One of the complaints by David Ray was some people use the FOIA to harass government entities. I'm sure there's truth in that. Whatever law we have is subject to some abuse. I'm not even talking about the Freedom of Information Act. Every law is subject to some abuse. Question is, where do you draw that line? Do you eliminate the good to get rid of the bad? Or do you try to cabin the bad as best as possible? And the efforts that were made during that special session in no way tried to cabin. They tried to cut the head off of the FOIA, in fact. So you can make it of any entity. I told you how to make it. Make it in an email. Then the next sort of trick about the FOIA is, in Arkansas, they can't charge you for labor. Why? Because you paid for it already. Because the legislature in 1967 told every government entity, part of your job is to respond to FOIA requests. So when someone makes a FOIA request, and sometimes you'll hear government folks respond, not all, to be clear, and I think a lot of government folks are quite responsive. And actually, when I've made FOIA requests of cows, always responsive. But sometimes they say, well, we don't have time for that because we have to do our job. And my response is, but this is your job. It's part of your job. And they can't charge you for that time. And that's critical. Because if they could, forget about the ordinary citizen being able to make a FOIA request. It would be cost prohibitive. And of course, you would put in the hands of the government entity the ability to determine the number of hours that they worked on it, right? And all of a sudden, it would be an enormous amount. That was another change that David Ray's bill sought to achieve. There was some little gap, like you got the first several hours free, and thereafter, the government could charge, and they could outsource it to a private company and charge you for the private company. And private companies don't charge less than government, they charge more than government, right? That's how it works. So that would be the end of government transparency. So again, there are laws passed every session that modify the FOIA, sometimes in a way that I think is positive, sometimes in a way that I think is not helpful, but that proposal wasn't an effort to tweak the FOIA one direction or another. It was an attempt to decapitate the FOIA. So when you make your request, tell them that I would like the request to be emailed to me. Why? Because what can they charge you for? I told you they can't charge you for labor. They can charge you for actual costs. And to be clear, that doesn't include labor. Actual cost means copying costs. So if you have things photocopied, they can charge you for that. That's okay. And different places charge different prices. A nickel is usually the lowest I've heard of, unless they waive the fee. And if they try to charge you more than a quarter a page, that might be an issue, meaning that seems above what's an actual charge. But all of that is for naught because we're not living in 1997, right? That you don't need photocopies, they can scan it. There's no cost to scan anything. There's no toner, anything for scanning a document, and then they can email it to you. If it's too big, they can Dropbox it. If they don't know how to Dropbox it, they can put it on a flash drive, and they can require you to pay for the flash drive, which is fine. And yes, sir?
Can they charge you for the depreciation of the scanner?
You're right. There's another word for it. Right. I've heard of people thinking about charging for that. I don't think I've ever seen a charge for that. But of course, it would be rather insignificant, right? Because all it is just moving the paper around. So I'd be interested in seeing what that is. It's the amortization, right, of the price of it. But it's not like when you, what is it, Chris, when you do on taxes, when you write off a piece of equipment? What's that called again? Depreciation, right. So it's not, depreciation schedules for tax purposes are at a much greater rate than the actual depreciation. Can't charge you a depreciation schedule. They can charge you actual depreciation, in theory, perhaps. I don't know the answer to that, but at best, that's all they could charge you. But it's a great question. And I have heard some folks talk about it. I haven't heard anybody seek to charge it yet. So there you go. So then you shouldn't have any charge. I always recommend that when you make a FOIA request, start out small and work your way broader. Because here's the problem. People say, well, I'm going to ask for everything. Well, and then what are you going to do with everything? That's the problem. Now, I hope you're making a FOIA request because you want to learn some information. One of the complaints, by the way, of some of the folks that were testifying in favor of David Ray's bill were, well, some folks make these large requests and then they get the records and nothing comes of it. Okay, so they looked at the records and they said, okay, you did all right. No problem. Now, other people did testify, and this is a problem. Someone makes a large request and then never even comes to pick it up. Yeah, that's an abuse of the FOIA because you're not actually looking at the records. It's permissible, but that's an abuse. I made a request recently. There was an article in the newspaper that I work at about the fees that the universities are seeking an increase of through the legislature. So I wrote to the folks at my university and I said, can you send me, I presume there's some document that went to the legislators. No, I'm sorry, it was a board meeting. Went to the board first. Can you send me that record? And I even wrote in there, I'm not looking for some sort of exhaustive search. So if this takes more than 15 minutes, let's have a conversation. Because you're sending me, then you're doing something I didn't want you to do. Now, you don't have to be in that position when you make a FOIA request. My point simply is, if you're really actually looking for information, having a conversation is useful. And I tell that all the time when I give talks to folks who work for government entities. If you get a FOIA request and it just seems like a mess, try to reach out to the person and say, I really just want to help you. So can we talk about what you're looking for? Now, sometimes they'll say, you're the government, you're evil, and they hang up the phone, or they won't, or they write you a nasty gram back in an email. All right, I can't solve all the world's problems. But that communication solves a lot of problems. Interestingly, so I got the records. They said, oh, well, actually, it's up on the website. Here's a link. Great. That's precisely what I'm looking for. I'm not looking to create work. So one of the things I looked at first was what the law schools are doing, because I teach at the law school. So I know more about that. And I saw some increase in fees at my law school. So I wrote back to one of the people on the exchange, but the one more linked to my university, not my law school. And I said, oh, can you get me whatever the underlying memo is for that fee increase? I'd like to see that. Well, I heard from the dean a little while. Actually, I had called the dean to tell him I was looking into this, but later. And he goes, Rob, why didn't you just call me to get that record? And I said, oh, I didn't think you had it. I thought it would come from main campus. But by all means, if you ever get a FOIA request from me, but not from me, call me, right? So it works both ways. And he said, actually, they redacted my name from the, they don't have to do that. There's no privacy involved in making a FOIA request. But it was an interesting exchange to sort of follow the dots around to see where it actually went. There was once, I'll tell you a little side story, once many years ago, where a FOIA request was made and the university council didn't want to sort of figure out what exemptions applied, so they wrote to all of the recipient. They wanted records from me, and I was on some committee, I don't remember, that they wanted our records, basically. So they sent it to all the committee members and said, well, gather these records. Okay, and you're permitted to do that. I mean, my employer can tell me to gather records. And they said, and figure out which exemptions apply. So I wrote back and I said, well, none of the other people on this email are attorneys, so I don't know how they're going to do that. I'm not the attorney for the university, so I'm not going to do that. And if you demand that I do, I'll say, no exemption applies. How's that? And then they quickly withdrew their suggestion that the recipient of the FOIA should be the determiner of whether the exemption applies. Let's talk about some of the key exemptions that do exist in the FOIA. There are a lot. One of the problems, and we'll talk about this if we have time, there are some exemptions that were enacted this past session. In and of itself, not a problem. But you keep poking holes in that FOIA, and then eventually you have a problem, right? It's like Swiss cheese. And so I'm not a fan of adding and adding and adding exemptions. But let's talk about some of the big exemptions and why they exist and how they work. Let me go back. Let me save this page here. So personnel records, not an exemption. So you can get the personnel records of an employee, but within that category, technically separate, but conceptually within that category are evaluation records. When your boss gives you an evaluation, those are exempt. Things that go into developing the evaluation, those are exempt. But other aspects of a personnel record are not exempt unless they are highly personal. And so you can get significant records about employees. You see this often done with police officers. Chris Corbett is here. He's a colleague of mine, a lawyer, practicing lawyer. And he and I have litigated FOIA cases, and he represents criminal defendants often. And he will get the personnel record of the police officer involved in whatever the traffic ticket or whatever. Did you get the personnel record in the recent case? You did. Was there anything interesting in it?
Yeah, he wrote 10 times as many seatbelt tickets as any other officer.
So the son of Richard Womack. Richard Womack Sr. is a state legislator, and his son got into a car accident. And I wrote a column, actually 2 columns on this. It got in a car accident. The state police showed up, to process the accident. And I watched the video. And the state cop, state trooper they call it, right, was professional the whole time. Nice guy, wasn't rude. I really don't like when law enforcement are rude, even in the face of people being rude. And so he was appropriate, but he made a mistake. At one point, he's filling out his form, and on the form it says, was the driver wearing a seatbelt? So the trooper gets out of his car, walks up to the damaged vehicle belonging to Womack Jr., which, by the way, has both side air curtains expanded, so you can't even see through the side, opens a door, tugs on the seatbelt, and as I understand, and I think this is true, but I don't know, if you can tug on a seatbelt and it moves, it means the person wasn't wearing it during the accident. Because if they wore it during the accident, it would be locked in an open position. That's the claim, and let's assume that's to be true, and my understanding is that it's true. So I'm not arguing that point. Well, what did he do there? He conducted a search. And the Fourth Amendment doesn't allow you to just conduct a search. You can conduct a search, but you have to have something before you do it. Often you get permission. And I suspect if he had asked Womack Jr., can I look in the truck, Womack Jr. might have said yes. I don't know. I would have said no, but because I don't allow people to conduct searches, irrespective of whether I have something to hide, right? That's the, well, if you got nothing to hide, no, I don't allow people to conduct. Here's why I don't conduct searches. I ain't done nothing wrong, so don't waste your time. So he didn't have that. There's certain other exemptions that don't apply. The other big one is probable cause. Probable cause, if maybe he could see from the outside that the seatbelt was extended. Well, that means, oh, I think the seatbelt was extended in a way, oh no, I'm sorry, not extended, the opposite. The seatbelt was hanging straight up and down. So if I can see it's hanging straight up and down, I can deduce that he wasn't wearing it. That's probable cause for a car to continue the investigation. But he didn't do that. And so Chris represented Womack Jr., and he made a FOIA request, and it turns out that this police officer writes, how many, 10 times?
Man.
Is it?
I saw it.
So,
Right. How many, please show me any and all records reflecting seatbelt tickets by this officer.
right,
And then I expanded it.
right,
Any and all records by any officer writing seatbelt tickets in this area.
right,
And there was 500
right,
by the other officers. He had 5,000.
right, right.
What?
Right. So it tells you something, right? It's something useful for the case. Chris won the case. The ticket was thrown out for lack of probable cause, for violation of Womack Jr.'s Fourth Amendment rights. Because those things matter, you know? Personnel records, yes. Evaluation records, no. Employee has a right to all of his records. So they can't say, well, no, that's your evaluation. No, no. If it's your record, you work for the government, you get it all. Let's go to some of the other big exemptions. Income tax records, exempt. Medical records, exempt. Adoption records, exempt. Education records, exempt under the FERPA, which is the Federal Education Record Protection Act. I'm surprised I remember that. But here's I made FOIA requests of previous administrators at my law school because I study admissions. And I look at admissions data to see the outcomes of letting in people with different scores. And one previous dean refused to produce some records for me. So I sued my employer. We wound up settling the case. I probably shouldn't have settled it. I probably should have litigated it for the point. But I had Judge Tim Fox, who's a state judge, and having Judge Tim Fox as a judge in any case is a chore. What I sought were called anonymized records. Like I didn't want record John Smith or anybody. I said, give me the data that show the admission scores and the graduation rate and the bar passage, all these kinds of things. All data that schools keep. And they said, well, that's privacy records. I said, no, it's not, because I'm not asking for any names. And I got an AG opinion that said the same as well. You often see, one of the biggest problems with FOIA is that government entities will invoke increasingly absurd interpretations of the exemptions. It's one of the problems with having all of these piecemeal exemptions. Because they can get away with it. Because for the most part, you can't hire that $1,000 attorney that I mentioned earlier to go litigate for you, and it's very hard for an individual to litigate a FOIA case. There's a woman, her name was Partney, which is entrapped, spelled backwards. She changed her name to Partney. I forget her last name. She went all the way to the Supreme Court, Arkansas Supreme Court. She litigated a case in which the government said, you can't ask for that many records. She said, I want all of the emails from this person for 5 years or whatever, something like that. They said, well, that's burdensome. The Supreme Court said, there's no burdensome exception in the FOIA. No, the Supreme Court did point out that we have a rule that says you're supposed to provide, the government entity is supposed to provide the records immediately if they're in use or in storage 3 days later. And the court, in that case, I believe, and another case said, yeah, but if it's things that you literally can't gather anywhere close to 3 days, then you're not going to be required to comply with that. But it is also interesting. It's 3 days only if it's in use or storage, but I've never seen a government entity not claim it's in use or in storage. Only once did I ever raise that as an issue. It was at the university, and there was someone was running for some position, like a faculty senate, faculty president. It was running for faculty president. Well, the faculty president, who was the incumbent, had access to an email that went to all the faculty. But you couldn't reply all on it, right? It was one of these listservs, right? It was one direction. So the opponent couldn't send a message to everybody, but the incumbent could. You know, one of the benefits of incumbency, privileges of incumbency. So I made a FOIA request for that, and I wasn't running, but I knew the person who was. So I made a FOIA request for that, the email addresses of all the people on that list. And then you could literally cut and paste it, right, into a new email. And I said, and this is neither in use nor in storage, because that notion is somewhat antiquated, right? In use is like, oh, well, I'm working on that piece of paper right now. Well, no, it's a digital file. And it's certainly not in storage because someone just sent an email based thereon. They sent it to me the same day. And they should have, too, to be clear. But it's the only time I've ever invoked that it should be in less than 3 days. Law enforcement records. Chris and I had a case in which the sheriff, the Pulaski County sheriff, had some dealings with a criminal, basically, right? And they finally arrested this guy. The guy claimed he was a big donor to the sheriff on video that we got pursuant to the FOIA. And they didn't want to turn over some of the records because they said it was an ongoing investigation that comes under these law enforcement. You can get most law enforcement records, you can't get ongoing investigations. Incidentally, even the ongoing investigations exemption is not written in the law. The language is more narrow in the statute, and the Supreme Court said, well, that really means ongoing investigations. It doesn't, but that's old, and I'm not going to fight that anymore. So they didn't want to turn it over, and I said, but you charged the guy already, and you've been talking about a plea agreement. And they said, well, if he signs a plea agreement, we'll give you the records, but otherwise we're going to trial. And I said, either way, I would think the investigation's over. How do you try a case when an investigation ain't over? I was before, again, Judge Fox, who doesn't like me. It's really only one of the few people in Arkansas. And so he denied my request without doing any research whatsoever, denied it right from the bench, and basically said, well, whatever the other side said. I appealed it, we appealed it, Chris and I appealed it, and we won, and it was sent back to Judge Fox. And then he made another lousy ruling. He said, I looked through the records, because they sent it back and said, you got to look through the records. It's called in-camera review, right, in-court review, and determine whether they're exempt. Now, meanwhile, time has passed, we got the records, but I still fighting the issue, right? And so he says, I looked through them, you don't have any right to those records, and therefore, by the way, you don't have a right to attorney's fees, $1,000 or less. And I appealed it again, and that is currently on appeal. And the reason I appealed it again, he never had the records. He claimed he did an in-camera review of records that the other side never sent him. That's how shoddy his work was. It's always an effort to keep up the fight, but that's the ongoing investigation record. There was a case that came out only a few years ago from the Arkansas Supreme Court in which someone tried to get some police records, and whatever police agency said, it's still an ongoing investigation because we didn't close the file. And it's one of these cold cases, right? And the Supreme Court said, at some point it's over, and forced the police agency. And they said, well, when's the last time you looked into it? 10 years ago. We said, that's not ongoing. Just because you haven't closed the file doesn't make it ongoing. Ongoing actually has a meaning. We talked about the working papers, right? There is a competitive advantage exemption, intellectual property, and that will bear on a law that was just passed. Certain electronic security, examination materials, military discharge records, a special exemption for public water systems. So you all have one. Records for concealed carry handgun owners, because it's a very conservative state and they don't want to turn over those records.
Can I interrupt on that?
Yes?
I lived in Virginia when the concealed carry licenses were publicly released to the Roanoke newspaper.
Right,
And besides giving folks a list of where to go rob people
right.
and find guns, at least one case of a woman who was in hiding from her abusive ex got exposed because of that. So there's some very real personal.
Well, and to be clear, there's always, whenever you get a government record, there's two things in a government record. And what's interesting about those records is, well, let me say it this way. There's operations of government, but the government operates in interacting with people all the time. And so the government scoops up all sorts of information about the citizens. And I, to the surprise of some, because I'm a strong transparency advocate, think that's a separate category. Citizens' privacy, to me, is a separate category, not employees' information, right? If you work for the government in that capacity, that information is public information. But we scoop up all sorts of information about individuals. And so the gun records is a perfect example of where I think it should go towards privacy, because that's not, you can have a list of how many gun permits you've given out, but who has it, that's an individual's knowledge. There was a similar proposal which did pass about people who win the lottery. And I was on the opposite side of the press association, the Arkansas Press Association, which I'm a member of. They said, no, we need to get that information. I said, well, I don't know, that's the individual. They're giving out the money. Well, maybe there's some fraud. Yes, there are issues in not disclosing as well as disclosing. But that's a tension, and I lean towards the privacy when it comes to individuals, to citizens. Government doesn't have privacy. So if you hear someone claiming government has privacy, that's just gibberish. Yes, sir, go ahead.
You said very quickly that there's a special water utility exemption.
Yeah.
What is that?
Oh, it's certain security records, and yeah, and we can go over that later. They somehow, came forward and got, it doesn't mean it's a bad exemption, by the way.
There's also a new exemption, I think came out of the Little Rock School District cyber attack.
Right.
That says you might be okay if you were having some urgent crisis with regard to cybersecurity to not give notice.
Yeah, well, that's Clark Tucker's law that he did a very nice job on, where information about cyber attacks and negotiations that can
Pay the ransomware.
Right, ransomware during the attack. That can be all done in what's called executive session. That means outside of the public meetings. That second sort of broad category that I said is encompassed by the FOIA, but I'm not going to talk quite as much about. Here's an interesting one. Settlement agreements. Certain settlement agreements are exempt. I'd have to go back and look which ones are and which ones aren't. But government always wants to keep settlements private. And so they can get a settlement agreement and require the parties not to discuss it. But the general rule is not that settlement agreements are exempt. So if you're making a note, put an asterisk, because it's in my book, but maybe the book is saying generally it's not. The point I wanted to bring out was it's actually the opposite, that often an employee will sue an employer, government employer. They'll settle. They say, you're not allowed to say anything. Okay, and they're allowed to put that in a settlement agreement, but all anybody has to do is say, please provide me with a copy of the settlement agreement. Recently, Jennifer Waymack Standifer, the last year, not just now, but last year, went to the annual bar conference in Hot Springs, and it was held at the Convention Center, which is a public facility. And they violated her First Amendment rights and told her she couldn't hand out the very petition that Nate was mentioning about trying to get on the ballot, strengthening of the FOIA. And the cops behaved badly, by the way. Not only did they violate the law, they behaved badly. And that was really unfortunate. And the Convention Center behaved badly. And by the way, the Arkansas Bar behaved badly as well. And I wrote a column called Bar Fight about that. And she hired counsel. She threatened suit. They didn't file suit. And all three entities settled. And I FOIA'd the government entities to see what was disclosed. Very little was written in the settlement agreement. It's all done on a handshake. It's okay. It's permissible. It's not transparent, but it's permissible. All right.
Here's one thing
yes,
that you use the library, or me as a foil here, that illustrates one of the things that make, in the common understanding, wrong understanding, be assumed to be an exemption, it's not. And you can pick up the story when I tell you a little bit of the lead.
Yeah.
I get an email from a library in another county saying, hey, I've got something I want to send you. Send me your non-CALS or maybe non-FOIable email.
Right.
So I accommodated him, knowing
it's FOIable.
yeah,
Right.
but not going to try to teach him. Just okay, here it is. Then when there's an FOI request, it comes. We generate
And you provide the record.
request
right?
and the document that he was trying to send to me. So you can.
Yeah, it's a very good point. It's a very good point.
It's the substance of not the platform.
That's right. The method of communication is irrelevant. Well, it's not wholly irrelevant. If you are using government resources, government email, it's presumed to be a public record. It's not necessarily, meaning you could get around that. You can say, I was writing my girlfriend.
It's a rebuttable presumption.
That's right. That's precisely right. I was writing my girlfriend. This was private information. It's got nothing to do with what's going on with the government. There was a case like that. Right. And the court ruled against the individual, saying it's still a government record because you were spending a lot of time and it was like a government contractor. So it wound up revealing sort of government behavior in the sense that you were kind of wasting a lot of time. But theoretically, something you write on a government email could not, it's possible it's not subject to FOIA because it has to be a record of government action, government behavior. The flip side, which Nate aptly points out, is it doesn't matter the medium. Doesn't matter if Hillary Clinton creates her own server, right? That's just as subject to the FOIA. Now what Hillary did was she said, well, I'll go through them, and a whole bunch of them got erased, So that's the problem when it's done on a private email. And so when this fellow, who I think is the head of the Library Association, or was the head of the Library Association, I think it was he, but I'm not sure, sent Nate an email saying, send me, where can I send something that's not FOIable? To yourself, right? Meaning nowhere. There's no such thing. if it's a government record. Right now, if he's inviting Nate to the bar mitzvah of his son, we have one of those every 3 years in Arkansas, then of course, that would not be subject to the FOIA. That's actually a good example. If Nate were to send an email to somebody, come to my son's bar mitzvah, and to use his Cal's email, that's not subject to, and it's just one email and he does it, on the side. That's not, that's.
I sent an email to my adult son saying,
right.
You need to check on my dog. I'm out of
Right.
town,
That's right.
my Cal's email account.
That's right. Not subject to the FOIA. That's exactly right. So we see a lot of these tricks. And as I mentioned earlier, what we see also is government entities looking for exemptions. And that's a problem when we have so many exemptions. We just passed a law, and so I'll move into the final part with at best 5 minutes left on my talking, where, let me just see where it was. Oh, it's about schools, right? So I don't even see it, but I remember it. So we passed a law that says Arkansans can look at school materials for the students. And it says that intellectual property, copyright, shall not prohibit that, shall not prohibit you from getting that information. And it shall be done in a way that's consistent with fair use, which is an exemption to intellectual property. Chris is an intellectual property lawyer, by the way. So there's a whole bunch of law there that I'm not going to even try to teach you because I'd have to learn half of it myself. But this book, my book, is published by Lexis, and I don't know, but I'm sure we share the copyright, but at best, right? Meaning either Lexis has it, I have it, or both of us have it. But that's it, nobody else, nobody in this room has it. So this gentleman bought my book, but what he can't do with my book is photocopy it and then give you all a copy. That violates my ownership right. That's what intellectual property is all about: patents, copyright, and trademark. And so the good part of that law says local entities, any government entity, can't use intellectual property as a workaround the FOIA. Can't kind of write a contract that says, oh, we wish we could have given this to you, but we can't. That part of the law makes sense. The part of the law where it says you must turn this over and it is fair use. Fair use is an exemption. What he can do is he can photocopy a few pages and hand it out to everybody here for educational purposes. Absolutely. That's fair use. And of course, librarians are quite expert, I mean that sincerely, on the notion of fair use because they interact with that doctrine all the time. And so the law kind of tries to make things fair use whether or not it's fair use, which is an independent determination. So I appreciate the effort. And why was that law passed in the first place? Because too many government entities said, oh, sorry, would so love to share all this information. Intellectual property, sorry, can't share it with you. The law also says that if it's shared with you, I don't know if always, or at least under some circumstances, you can't thereafter share it. Why? To maintain that protection, that intellectual property protection. But that runs afoul of the notion of the Freedom of Information Act, which is I'm seeking a public document, and once I get it, I can do anything I want with it. I'm free to share it everywhere. Why? Because you've just told me it's a public document. So how can that be? How can I be restricted after you gave me that document? So good effort. We'll see how that plays out. The biggest change is the law that was passed by Clark Tucker, and the biggest portion of that law deals with the section that I wasn't talking about, the open meetings. And the open meetings portion has its significant difficulties. It says that any governing body, when they meet, they must meet in public, and only then can they discuss the matters that are on the agenda. So two governing members of a governing body can't meet before the meeting and say, I'm going to make a proposal that the city build a pool. Oh, okay, that's a good idea. I'll back you up on it. They're not allowed to talk about that before they get to the meeting. It is a bit unrealistic. And what entailed a public meeting and what wasn't a public meeting, was never defined in the law, was poorly defined by the Supreme Court intentionally. They said, it's not our job to define this, so we're not going to define it. We're going to answer this case, but we're not going to define what it is to hold a public meeting. And Clark Tucker's law does a good job of better defining. It's not perfect, meaning I think he did as well as one can do, but you'll always have problems. But it says, look, if you're on a governing body and you have a reasonable basis to think this is something that's going to come before the governing body, you can't talk about it with other members of the governing body. The legislature is not subject to that, by the way. And there's a lot of people complain about that. And there was a bill, again, this session and the prior session, to whatever the number is, to say a certain number of members of a governing body can talk before they get in public. And I opposed that bill, but I said the same thing I'm going to tell you. I don't think it's unreasonable. I think on balance, we shouldn't pass it, but I understand it. I think there is some element of not allowing folks to talk at all that's a little unrealistic prior to a meeting. So I get it, and I'm sympathetic. And maybe there will be in the future some version of that bill that I could support. I didn't support the bill. I testified against it in the Senate. It passed the Senate, notwithstanding my testimony. Can you believe it? But it failed in the House, and I didn't testify in the House. So it's proof that when I don't testify, good things happen. There's, of course, plenty more to say on the FOIA. I hope I've given you a taste of how it operates, what it does, and how you can use it. And, of course, I would love to take any questions if you have any. Yes, sir. Oof. Ooh.
Hi, Professor.
Hi.
You mentioned earlier some of the counter arguments when they were trying to pass the law limiting FOIA here.
Right.
And one thing you said was there could be a high volume request and then someone doesn't even come to pick it up or retrieve it, and
right.
you described that as abuse.
Right.
Is there anything to limit that or mitigate the effects of it?
I think it's something we actually do need to work on. I think it's a great question. There is a fellow who works at A-State, Arkansas State University, who was on the FOIA, we were both on the FOIA Commission, which is an entity created by the legislature for the purposes of advising the legislature. And it works sometimes well, and it doesn't work other times so well. And he and I were often on different sides when it came to the FOIA. But to his credit, he's raised this a number of times, and I've agreed with him. I said, yes, I think we need to think about some way to address that. One of the things, I wound up supporting a bill that Jason Rapert, when he was in the legislature, had sponsored, and it was about video recording by police. It allows the police to charge after, I think, Chris, do you remember 3 hours, 2 hours? 3 hours. You want to get a video from the police, for whatever, right? The dash cam and the body cam. You get the first 3 hours free, and thereafter they can charge you, but not for the labor. When that bill started out, written by the Arkansas County Association, they wanted to charge you for the labor. Arkansas County Association and the Municipal League are generally not friends of the Freedom of Information Act. John Wilkerson, who works for Municipal League, is a very smart lawyer and a nice guy, and I like him. But as entities, neither are friends of the FOIA. I've been able to work with John on some laws, and that's a good thing. So I have a better relationship with the Municipal League than I do with Arkansas counties, because I don't have a relationship with Arkansas counties. So they wanted to charge labor. Well, I told you earlier, right, as part of my talk, you charge labor, you kill it. So I came up with the idea, no, charge by the hour of video beyond the first 3 free hours, and we all came to agreement that it would be $20 an hour. That's a great way to cut down on just sort of frivolous requests, because people are real fast to send me all the video, right? Well, okay, but it's 20 hours, it's take away the 3 hours, right? Let's assume 20 hours above the 3, that's $400. It's not a ton of money, but you're not going to spend that money unless you really want that. And so that notion, I think we can consider. But the difficulty with records is it pages? Is it data? Right? I asked for data when I asked for that admission information. By the way, they can't tell you, well, we never created the record. You have the data? You have the means to print out that data? That's a record already. So it gets harder when you deal with paper, and it gets harder when you don't know the size of the universe. Maybe the person's asking for something that's 1,000 pages, and it's, that record that I asked for from the university just recently, that they sent me the link to, was 385 pages. But it's nothing, it's a PDF, right? So that was not a lot of work. So the notion exists, but I don't know yet how to implement that notion. But I'm supportive of dealing with it, yes. And it's a great question. By the way, how do I tell the difference with the black insignia between major and lieutenant colonel?
It's silver if it was the shiny one on my dress.
Right, but when it's black.
Versus got gold for the major.
Oh, is it really? They still got that gold. Okay. Go ahead.
Well, I mean, like, how could you begin to limit the FOIA requests if you have any sort of a free tier? Because you can start chaining requests over and over again. So if you wanted 30 hours but only the first 3, you just create 10 FOIA requests.
There was something, I don't recall, you're absolutely right. I think there was some time limit, like once per year or quarter or something. There's something in the law that deals with that. But you're right, all these things have their limits. But I thought that was a reasonable approach to deal with the issue. And I wasn't a huge fan of it, but I wound up supporting it because I thought it was a reasonable compromise.
Is there anything in the law that would say that you can't do things in bad faith, like your suggestion?
Right. The problem with the bad faith requirement, and I appreciate that because that's what we're talking about, and the major will appreciate that. He's a law student. You didn't graduate yet, did you? Oh, you graduated. He's a lawyer. Did you take the bar yet? I did. And you passed?
I'm not practicing.
Okay, but you're still a lawyer. Once you pass the bar, you're a lawyer. You're precisely right. We're talking about bad faith. The problem is, if you use language like that, then who makes that call? The government entity, right? Because who's the first person, who responds to the FOIA request? It's the government entity. And if you don't like their response, you can go to court. So if you put a bad faith requirement, then the government gets to judge whether your actions are in bad faith. Ultimately, it can go to court. That's dangerous, though. I like objective measures. That's why I like 3 hours for whatever it was, quarter, year, whatever, $20 an hour thereafter. Nobody's monkeying with the hours it takes to produce the video. We know how long it is because that's how much video you got. I like objective stuff. I think it works better for transparency. So, yes, in the back.
Thank you, Professor, for the valuable information. My question is, can a college applicant request a copy of college decision details after being denied an admission to that college?
Oh, that's a great question. Yeah, I'll repeat it. Can you request, if you apply to college and you're turned down for college, can you request the denial information that they may have? I like that question because, of course, normally you couldn't, in the sense you can't ask about another person, but this is this person. And as I said, education records are an exemption, but it imports the Federal Education Privacy Records Act, whatever, FERPA. But FERPA says you get your own records. So I think you might be able to ask for that. That's very interesting. We should test that. That's a wonderful question. Now, I don't know how much records they keep, but they keep something. So I think that's a wonderful inquiry. If you know anybody or yourself who is in that opportunity, make that request. And if they refuse you, get in touch with me. We can go through and look at what exemptions, because I expect they will raise an objection. But nothing comes to mind offhand. So I like that question. I like how you're thinking.
We're making law in the library.
Well, that's what we try to do, right? Any other questions? Yes. Yes.
You got me persuaded that your book is more authoritative. I'm sure it is.
Then what?
Well, that's actually the question, because the Arkansas Freedom of Information Handbook was the third one on my list of stuff to read to make sure I'm.
Well, the handbook's not bad. The handbook's put out by the Press Association. I worked on an earlier version. I don't think I worked on the most recent version, but to the extent that the Press Association is going to put out a new version, I'm going to work on the new version.
So what my hope is with this is that you can tell me that if I read this one, then I don't have to read these other ones, because this is going to.
Well, yeah, my book covers everything in the handbook and then some for sure, right? The handbook's 30 pages or something.
That's true. It's brief, but it's also printed 2025. And so the question is going to be the very first thing you said. The 21st, yes, sir. So I was thinking, since you're working on the next edition of your own.
Right, but this is just a cover. Is this the one from the Press Association?
Yes, sir. That's the first page of it that I printed off, just so I can, kind of get my titles straight.
Okay, well, I'm not familiar. If it's 2025, I should be aware of it, but I'm not. So I need to look into that.
But that aside,
Yeah.
do you happen to know what changes have transpired since you printed this edition? Maybe.
Well, there are. We passed about a dozen laws, and there's been a handful of cases, several of which Chris and I litigated. So there are some tweaks to the law. Yeah. It's always moving.
That's why there's another edition coming.
It's coming, right? I'm working on it right now. I'm working on the new edition right now. That's exactly right. All right, well, folks, thank you so much for coming. I really appreciate it. Mhm.
You should put your number up here, your email address for people.
Oh,
to
yeah,
follow
yeah,
up.
yeah, yeah,
You
sure.
wanna tell them what it is?
Yeah, folks, you can contact me. Easiest probably at the school. It's my first two initials and my last name, R.E. Steinbuch, STEINBUCH, at ualr.edu. That's probably the best.
Contact the library, and we'll get it for you.
They'll get it. Yeah, exactly. Well, thank you.
Great
Thank you
job.
very much.
Enjoyed it.
Appreciate it. Me too.